What's up, everybody? It is early on a Saturday morning. I'm back in the bunker here, the home studio that is still not complete, but will be complete hopefully in a couple weeks. And I decided to do a video early this morning because my DMs have been flooded, unlike many other times. Like, this is one of the most asked questions I've had in months, and that is, what is going on with John Pryor, Chad Daybell's attorney, who's been his attorney for years on this case, who has fought hard for Chad Daybell, and now all of a sudden wants to withdraw? Is there a problem between he and Chad Daybell? Is there some kind of myth as to what John Pryor wants to argue versus what Chad Daybell wants to argue? Does John Pryor want to point the finger at Lori Vallow? Is it just a money issue? Has Mr. Green not shown up, as lawyers like to say, when the money stops coming in? Is that a good enough reason to get off a case? What do the rules say about that? Does the judge have to let John Pryor withdraw? A lot of interesting questions that we're going to get to, a lot to unpack in this motion to withdraw. We're going to look at the Idaho rules. We're also going to look at some of the rules from Florida, from the Middle District, because we've dealt with this in the past as well, as every criminal defense lawyer has. If a client stops paying, do you have to keep working? Should you have to keep working? Different judges in different courts and different jurisdictions see it different ways. I want to know what you think about it, but wait until I kind of explain the different situations and scenarios. And there are a lot of nuances and things that make this case very unique. And this case is not just your run-of-the-mill, what are you going to make the criminal defense lawyer do? Because there are so many major things and rights at play for Chad Daybell. So we're going to break it all down. We're going to talk about all of it this morning. I'm going to try to be in the chat when this video plays so we can get to your comments. But either way, put your questions in the comments, put your thoughts in the comments. Make sure you like the video if you haven't already. And please, subscribe to the channel. Make sure you subscribe. It helps us out a ton. It helps us know what content you like, what you want to hear in the future. That's how we got this sent to us so many times. And let's jump in to this motion to withdraw. So, pursuant to ICR 44.1, undersigned counsel hereby moves to withdraw as counsel from this case. Since May of 2021, undersigned counsel has represented Mr. Daybell in this case and the related previous case under case number CR 22200755 prior to that time. In that time, undersigned counsel has undertaken as sole counsel all matters of representation, including obtaining and reviewing discovery, conducting investigation, and hiring and working with numerous experts. So almost 3 years John Pryor has been on this case. And he cites ICR 44.1. Let's take a look at that real quick. All right. That says, leave to withdraw. No attorney may withdraw as an attorney of record for any defendant in any criminal action without first obtaining leave and order of the court on notice to the prosecuting attorney and the defendant, except as provided in this rule. Leave to withdraw as attorney of record for a defendant, here's the important part, may be granted by the court for good cause. Meaning, you can't just leave. You've got to show good cause as to why you need to leave. So let's now read the rest of the motion to see if John Pryor provides good cause to leave. Now, to contrast that, I guess now is probably a good time for me to just show you real quick what it says in the Middle District rules here in Florida in federal court. If withdraw, so this is a reason why you can't withdraw, right? Here's how you appear. Here's how you withdraw. To withdraw, you must notify each affected client 14 days before. You must file a motion that includes certification that the lawyer has provided 14 days notice. If the withdrawal will result in the person proceeding pro se, you need to put this information in there. The withdrawing lawyer, not the lawyer's firm or somebody else, but the actual lawyer has to file this motion to withdraw. And here is the reason you can withdraw, highlighted in purple. If withdrawal might cause the continuance of a trial A lawyer cannot withdraw absent a compelling ethical problem, emergency, disability, or death. So the Florida federal courts take it to the next level, and we've experienced this. And here's the thing, we're going to talk about all this, but you can't just say, I'm out if it's going to continue the trial, which means it's going to prejudice the defendant. So no jurisdiction wants that to happen, but Florida takes an additional step to say, if that's going to happen, you can't. That's the rule. In order to get out now, you have to be an exception to the rule. Now, Idaho and other jurisdictions don't necessarily say that, even though they don't want to prejudice the defendant. They don't want to continue the trial. And some of the things that they say are a compelling enough reason is an ethical problem. That doesn't say money. An emergency, disability, or death. And I will just tell you from experience and from the case law, usually money does not fit any of those factors. So what do you do as a lawyer, right? People don't usually feel bad for lawyers, and I understand that. I don't usually feel bad for lawyers. You know that going in. You have to know your jurisdiction. You have to know what they're going to allow and not allow. And in Florida and federal courts, you better get paid up front because you're probably not going to be able to withdraw later. So let's read some more of the motion. Let's see what he says about money and some other things here. Bring that back up. All right, here's Pryor's motion to withdraw. Let's continue. Mr. Daybell retained undersigned counsel with personal funds. At a hearing on January 19, 2023, so about 2 years into his representation, the court inquired of Mr. Daybell and declared him indigent. So he's been indigent for almost exactly a year. Mr. Daybell does not have the ability to pay for counsel's continued services, and Mr. Daybell seeks the appointment of 2 capital qualified attorneys to represent him in this matter. So before we get to the capital qualified part, let's discuss personal funds not having enough money to be able to pay for continued services. Nobody feels bad for a lawyer. As I already said, most of the time, even the court doesn't. And they're like, too bad, you don't get paid. We're not going to screw the defendant. Do your job, finish representing him. And that's all well and good, especially if you get paid a flat fee up front saying, pay me $500,000 to represent you for this charge, whatever it is, okay? $50, whatever it is, you decide as the lawyer and the client decides. If they pay that, you continue in finishing representing them. But what if you take it on an hourly basis and somebody's paying you hourly? And let me give you an analogy to a non-lawyer, right? Let's say you work at any business. Let's say you work at an office and you make $20 an hour. And your boss says, I'm going to stop paying you, but I want you to keep working. And somebody else, like a judge, says, you have to keep working at this office and not making that $20 an hour. Does that seem fair? I think everybody would say no to that. Doesn't seem fair. Now, it's different. Usually if you work at an office and that's your only job and that's your only sense of income or source of income, then to be able to work for free would literally put you at a detriment. But lawyers, most of the time, private lawyers, have lots of clients, not just one client that they're living off of and eating and paying for their family. So I understand the differences. So let's take it to kind of a higher level. Let's say construction. You pay a general contractor cost plus and they're billing you every, quarter, whatever it is, and you stop paying. Do you think they're going to keep building your house? For the most part, no. And usually they're not forced to if they have done the work that they have been paid for, right? You paid them for last quarter. They did last quarter's work. Sometimes you're even a month behind or a quarter behind where they've built another part of the house that you owe them money for and you don't pay them. Nobody's going to make them finish building that house, wasting their time and losing money to finish building the house. And that's not the only house they're building. That's not the only source of income for the most part. But lawyers are looked at differently. And the important part is lawyers should know that. We're not building a house. We're not punching in and out. We are representing people in some of the most difficult parts of their lives. And I will say this is different in criminal law. Usually criminal law is where judges will not let you withdraw just for money problems if you want to. And that is usually the rule. You say, Judge, I'm not making enough money on the eve of trial after multiple continuances, a year of representing him when he's been indigent. Now, all of a sudden, you want to withdraw? Are you trying to create problems in the case? Are you trying to create appellate problems? Are you trying to create another cause for a delay and a continuance? Are you trying to create issues for the defendant so that we'll get rid of the death penalty and circumvent the actual rules and arguments in case law? You better not be doing that. I've seen some questions about that. That better not be what Mr. Pryor is doing. And I don't think that's what Mr. Pryor is doing, because that would be unethical. If you've hung around the case and you're using your withdrawal to create an appellate issue or force the court's hand to continue the case, that's not zealously representing your clients within the rules. Because, I mean, you can go as far as to say making witnesses disappear is zealously defending your client or representing your client. Yeah, but you can't do that. That's not morally and ethically appropriate in the judicial system and would never be allowed or upheld or agreed to by anyone as appropriate. So you can't hide everything under the guise of zealous representation. So money, I can understand how it can be frustrating for lawyers, and we have withdrawn from cases before. Usually the more common issue is it's the beginning of the case and the client, paid part of the upfront fee, but not all of it. We return that part, whatever it may be. Or a client is charged with DUI, let's say, and you quote them a fee for DUI and they pay the fee for DUI. But then it turns out it was actually DUI manslaughter, and they actually hit somebody and they didn't tell you about it, and the charges were wrong in the system, and it's actually something much more significant and severe than you originally quoted them the fee for based on the work that it would take for a DUI, and the charges change and you can return the money. Or maybe if it's DUI, but they also have these other charges and they expect you to represent them on the other charges, but you only are going to represent them on the DUI. So things like that happen as well, where there are disagreements or misunderstandings about what you're representing them for, and the money's wrong, and those are all understandable. That doesn't seem to be what we have here. It seems to be the one charge, the one crime, what all of us know about, that John Pryor has been on from the jump, and now he wants off. We also need to hear about what Chad Daybell thinks about this. So let's continue reading. As this court is aware, this case is both extraordinarily complex, and the prosecution is seeking the death penalty, which requires counsel to essentially prepare for 2 trials. Here is when we get into this case being unique. Death penalty, extraordinary, basically prepping for 2 trials. Reflecting this complexity and the work required to prepare and try this case, this court has set aside 2 full months for trial. And the prosecution team consists of no less than 5 attorneys from 2 county offices, including an out-of-state attorney hired at taxpayer expenses. So that is just a little glimpse into how unfair the process can be to criminal defendants sometimes. Is you've got to pay for all this yourself. Meanwhile, taxpayer dollars are going to pay for 5+ attorneys, investigators, all these people to have an army against you. That's why it's a bit of a David versus Goliath. And I get it. A lot of these people are guilty. A lot of these people committed crimes, but some of them didn't. So an innocent person also has to fight this battle, also has to climb up this hill, also has to swim against this current. So that's tough and daunting. And Pryor says remaining on this case would require undersigned counsel to work around the clock, more than full time, for more than 4 months without compensation and without assistance of any other counsel. I agree with him, and I understand why this is an issue. What I don't understand is why has it taken so long for him to realize this? Everybody's been saying this from the beginning. The court has warned him against this. The court has told Chad Daybell what his rights are. 2 court-appointed death penalty certified attorneys, yet John Pryor has continued to stay on this case. Now, somebody can be ruled indigent or declared indigent and still continue to pay a lawyer, have a dad pay or somebody else pay, a brother, somebody else foot the bill. So just because he was declared indigent in January doesn't mean that John Pryor hasn't been getting paid since then. But maybe the well has dried up at this point. It just seems strange to be making an argument that everybody's been warning Chad Daybell about the entire case. This motion is made with Mr. Daybell's full consent. That's important. What does Mr. Daybell think about this? Mr. Daybell has requested from me that he be given 2 capital qualified attorneys for his trial. Now, here's an interesting question. When did he first make this request? Has he been making this request for a long time? Why have you stayed on the case if this is a request he's making? I don't know those answers. Maybe the request was made yesterday or the day before he filed this motion. I don't know. I have made a diligent effort to find a lawyer to assist in this matter for a significant amount of time. The attorney who I located and agreed to try to get qualified has not yet been approved by the Public Defense Commission. So you have to be, we talked about this, you have to be on certain lists and in certain groups to be able to be appointed to cases like this, to be able to get paid by taxpayer dollars as a criminal defense attorney. If you're not in the public defense or a public defender's office, it does happen. It seems like John Pryor's in there as well, but we'll see why he thinks he shouldn't even be appointed to continue on this case. The time for him to be of any assistance to me in preparing for this trial is long gone. So he's saying, I did try. The delays are not my fault. I tried to get somebody qualified. I tried to get him to help me on the case. And it's just all these delays by, red tape in the government have screwed Chad Daybell. Because Mr. Daybell is facing the death penalty and has been determined to be indigent, he is statutorily entitled to appointment of 2 counsel who are capital qualified at state expense. This is true. This is what makes it unique. This is why I think ultimately Judge Boyce will grant this motion. In other cases, and probably in federal court in Florida, I think they might deny this motion and say, too bad, you've got to stay on the case. We're not going to ruin it for this client. We're not going to continue this case. We're not going to step on more of his rights because you didn't get paid enough money. The Idaho State Public Defense Commission maintains a roster of capital qualified attorneys, and we know that from Lori Vallow's case. While undersigned counsel could accept appointment to this case, so John Pryor is on some of those lists and available to be appointed. But he says only if it were non-capital, meaning John Pryor, which we've already known from the jump, is not capital qualified, not death penalty certified. Now, why has he been able to be on this case the whole time? Well, it's a free country. People in this country have rights, especially when it comes to the criminal system. If they are comfortable and confident in a private attorney, they want to pay with their own money and have represent them. That is their right. That is a right that Chad Daybell exercised to this point. He wanted John Pryor, but now he can no longer afford to have John Pryor on the case. Therefore, the second best option is 2 death penalty certified attorneys to be appointed and paid for by the state. And John Pryor, because he's not death penalty certified, is out. It sounds like to me, he's not bailing on Chad Daybell. He doesn't disagree with Chad Daybell. There's not a fight about pointing the finger at Lori Vallow. He doesn't say, oh, Chad Daybell, now I think he's guilty. I don't want to represent him anymore. It seems like a pure money and time issue. And it also seems like John Pryor will help the transition with the public defender's office. The judge will order him to do so, as we saw in the Delphi case. So I don't think there's going to be any issues there, but it is interesting. Has he been qualified the whole time to handle this case? Because Mr. Daybell is facing the death penalty, undersigned counsel, meaning John Pryor, cannot be appointed pursuant to the statute. The counsel therefore moves to withdraw. So it seems like John Pryor, to give him credit, wants to stay on this case, has probably worked for less than he usually charges on this case, or has stopped getting paid at some point, and was trying to help find somebody that the state could pay to get on this case. And he would even accept appointment to this case if he was so qualified, but he's not. So to give him credit, it does seem like he's trying to do everything right and what a lawyer should do in this situation, which is why I think Judge Boyce will at least look kindly on it, as kindly as he can. He's probably going to be frustrated because I don't see how this doesn't cause a delay. All John Pryor has said is how voluminous everything is and extraordinary and complicated and multiple trials, and it's impossible to do this quickly, and we need continuance after continuance. So I would expect this to create a delay. I could be wrong, but we'll see. Notice is hereby given the 30th day of January, that on the 30th day of January 2024 at 9:30, counsel may be heard. So that's when the hearing is going to happen. January 30th, 9:30 a.m. And we will see if Judge Boyce allows Chad Daybell to withdraw. John Pryor to withdraw from representing Chad Daybell. Let me know what you think in the comments. Is it a fair argument that if you're not getting paid as a lawyer, you should be able to withdraw? Is there a line? Because a lot of times there is a line. A lot of times there's a trial fee. And if a client refuses to pay the trial fee, should the lawyer have to try the case? How does that work? as far as what a judge thinks. I know what I think. There's a contract and you agree to pay a trial fee, you should have to pay the trial fee. I know I'm a lawyer, but if you sign the dotted line saying I'm going to pay X amount of dollars, you should have to pay that. You should have to honor that contract. And if you don't, I don't think the person should have to do the work. Now, I think lawyers should set it up in a way that appropriately represents their clients, the timelines of when this stuff happens to make sure this issue does not come forward or happen. And then you have the whole conversation about, like, if a lawyer stops getting paid, are they going to be at an irreparable conflict with their client? Are they not going to try as hard? Are they going to screw their client? Now, I hope lawyers wouldn't do that. We would never do that. But some lawyers are probably petty because some people are petty, right? And that could just become a detriment to the client. And the judge has to try to weigh all that, because you don't want to create problems or allow problems to continue as a judge that may become appellate issues. So it's an interesting discussion. I don't think there's anything nefarious going on here between Pryor and Daybell. I don't think they're at odds. I don't think this is a last-ditch effort to continue it. I think most continuances would be granted if the defense can come up with a good reason. I think this purely comes down to Mr. Green. I think the money has dried up, and Pryor's like, I got to feed my family. I got to work. I got other clients. So now it's time. You're indigent. You have a right to 2 death penalty certified lawyers. Let's get them in there. Let's get you proper representation, and let's move on. That's what it seems like to me, but I want to hear what you all have to say. Very interesting. And sometimes people's own decisions get them into these positions. And Vallow and Daybell wanted private counsel, and I cannot blame them one bit. And they picked counsel that was not death penalty certified. And so here we are. Here we are. So some wild news coming down. I think it was late Friday. I don't even know. It's early Saturday today. That's why my voice sounds like I just woke up. I literally did just wake up. So let me know what your guys' questions are. Hit that subscribe button for me. It's free. We love to have you join. Hit that like button, and I'll try to be in the chat. I appreciate you guys joining me as always. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.